All right, good afternoon, everyone. Thank you for sticking around. Thank you to GLG for a fabulous symposium. I think it's absolutely correct that it's appropriate to have this panel to bookend where Maria Jose started yesterday. In her presentation, or her memoir, as she called it, she talked about, as I took it, the march forward in terms of making collective action available for consumers I think, again, one of her terms was to find a remedy for their rights. And I think that we could all agree that in the abstract, this is a good thing, right? It's a good thing when people have an opportunity to correct the rights that have been wronged. In the concrete, however, it's a little more ambiguous. On one hand, there are times where corporate actors have done things that are wrong, and I think it's even fair to say that those corporate actors in many instances want to fix the problem and move on. There are other instances where the power of collective actions and the exposure can put companies in very, very difficult positions in terms of how they run their business and they move forward. I was interested in the panel on U.S. class actions talking about an instance, I don't remember the number, but a significant amount of data breach issues are caused by human error. Not anything done willingly or intentionally, but human error. I also heard about hypothetical damages of $500 billion in an instance like that. And situations like that, I think if I were in-house, I spent the last 30 years defending companies in consumer class actions, but that would be very troubling. That's what our panel is here to talk about today. We've heard from plaintiff lawyers, we've heard from defense counsel, experts, vendors of various types. The presentations have been terrific, but we've not heard from the people who are dealing with these issues from an in-house perspective. So I'm delighted to lead this panel. I'm going to allow my panelists to introduce themselves and talk about their roles, but just by way of high-level introduction, Joana, immediately to my left, is a senior legal counsel for Accenture Portugal, based here in Lisbon. We have Kilo. He told me I pronounce his name Kilo like J-Lo, so that's easy for me to remember, is the head of product legal and content safety at Welltech. He's based in London. And then Miguel, to the far left, is a chief legal counsel at Banco de Investimento Global here in Lisbon. But in addition to that, I'm not sure if it's your day job or your night job, Miguel is also a lecturer on the Faculty of Law at the University of Lisbon. So I'm excited to have this panel to address a number of issues. I'm going to start with a question I always like to ask my clients or prospective clients. What is it that keeps you up at night in this world where we have not only the substantive type risk of data privacy and all the other things we've talked about, but a new regime or certainly an expanding regime of collective action? So Joana, why don't we start with you and tell us what keeps you up at night? What's keeping you and also your business clients up at night?
Thank you for the question, Scott. Well, in my role, I pay close attention to the risk that is imposed by the fragmented regulatory landscape. And this is especially important when it comes to data privacy, AI, cybersecurity, and these hot topics of today. Actually, the lack of consistency in what concerns to AI, for instance, and other emergency technologies worldwide is quite a challenge. And aligning global operations with these various regimes is not an easy task. And at this respect, let me just mention that I think that we need to be prepared as lawyers to deal with different systems and regulations, and need to be prepared to there more than ever. Actually, this has been already mentioned during this symposium. Also, another risks that I always look to are concerned to corporate governance, competition practices, which may vary also from country to country. Well, to manage this, what we used to do is to have a strong focus on the implementation of governance frameworks that we localized whenever is needed in order to comply with local legal requirements. We also invest in technology to track and to manage these risks. And this is an important tool for us these days. Of course, we work with multidisciplinary teams around the globe. And of course, take leverage of our global network. But besides this regulatory risk, I would like to bring here a trend that is connected with another risk that is increasing, and it's a trend that is identifying the brand new Accenture Life Trends 2025. Has been published a couple of weeks ago. And this report called to this trend as a cost of hesitation, and this is very interesting. At the center of this trend is people, news, hesitation reflex on when they deal with anything online, and the cost that is represented to who is doing business in these platforms. So let me, before going into details, and I will have some interesting figures here, let me emphasize that emerging technology, and I'm an optimist regarding that, is completely transformative across all industries. It's transforming the way we operate, we do business, it's transforming our lives. I think we all are testimony of that, especially during the 2-3 years from now that with ChatGPT and other tools, we are already see how these transform a lot the way we do business and our lives, as I said. However, the rise of these new technologies increase and make incredible easy to produce deceptive and fake content. And this brings to a risk connected with brand trust. So this is, as is called in this report, the erosion of trust in digital technology. And I think this is interesting because the companies must implement the correct measures in order to avoid that their brands or their products are affected because of this cost of hesitation that I was mentioned. So I will identify these risks as the main ones that in a global company that has global operations will look to at the first place.
Thank you very much for that. And moving on down the line, Kaelo, what about from your perspective? I will ask another question about this later, but I think that it's fair to say that all companies at some level are digital companies these days, but I think no more so than Welltech. So maybe you can tell the audience about what Welltech is and what it does, and in particular, what keeps you up at night.
Thanks, Scott. Look, my career over the past 5 years has been very fascinating, coming from big tech, what has been labeled today as the bad guys, where I was Associate General Counsel at Meta, and then moving over to Welltech, which is probably one of the fastest growing wellness and fitness companies in the world. But then you hear that with great power comes great responsibility. So you're playing in a space that has other big players like Nike and Strava and Noom, and companies basically that are focused on basically saying that what they have on their apps do exactly all the good work in the world for people who use their apps. So you have like down to like some of our apps that are very popular, like Yoga Go, which is like a well-renowned yoga app, Muscle Booster, which is a very well-known bodybuilding app, Walk Fit, Fast Easy, and the likes. And these are apps that compete in the wellness technology sort of space. And these are apps that are used globally. So there's a regulatory crisscross across the pond where you have regulators that are very bullish, like the FTC, handshaking across the pond with the EU regulators, someone here, I think from Cooley, hit the nail on the head when she said that EU regulation innovates just as fast, probably even faster than US technology. So they're just, while one side of the world is really innovative about, like, you know, the big tech and really like mid tech, the EU is innovative with its regulation. So I mean, what keeps me up at night, probably in the daytime too, it's massive insomnia when you're working in the house. It's really just how to handshake a lot of the good work that we're doing, especially around things around user safety, substantiation, which is a very big deal in health tech. Essentially, if you look at the trend, especially around litigation, you would find that some of the massive hits have come against companies that have either not been able to substantiate a lot of the claims on their apps, have made cancellation. Well, I mean, that's a massive problem across like subscription-based technology. And we've seen Amazon also get a hit publicly as well. But the perception that cancellation is difficult can be a problem. The FTC recently just came up with a one-click cancellation policy, which is interesting. But for us in-house, it is very important that ethically and from a user's perspective, because whether I'm in-house at Welltech or at Facebook or wherever it is, I'm a user first. And so I have to embrace the good sides of the app as well as the bad. And you know, these things are developed by people who want the best out of, you know, everybody, who want the best out of individuals. And I want to balance this on the altar as well of profit making. And so we have to be able to look at these things and say, is cancellation difficult, right? Are users getting the best sort of like value for their money? Because these are essentially what the regulators are looking at. They're looking at the trends, whether it's on ROSCA or on the CCPA, or whether it's with the DSA, and they're saying to themselves, where exactly has this company fallen short, in a nutshell? We're having a lot of meetings as well with some of our supporting counsel on the other side, our OCs who also understand the business that we do, and getting as much advice in there. So we're implementing design from the start. So whether it's privacy by design or just generally speaking, compliance by design, you're literally innovating in-house at the speed of the regulator. So you're asking yourself the questions they would ask you. You're doing the audits internally that you will be subjected to, whether it's at the pre-trial stage or you know, whether you're slapped with a class action. Thankfully, that hasn't happened anywhere I've been in the past couple of years, or whether you're just dealing with, whether you're just being proactive. So I tend to think about a lot of these things with several yards down the road. One other thing that will always be top of mind as well would always be the fact that because of the regulatory pressure on platforms like the App Store platforms and Google platforms, there's been what I would label as secondary regulation. So you would also see it in things like the App Store suits against Epic Games, and the recent complaints from companies like Spotify as well. And so the extended arm of regulation on big tech through whether it's the DSA or whether it's ROSCA has had such an impact on big tech that there's now secondary regulation, in a sense, from them on other companies like Spotify, like us, like Nike, you know, like Strava. And so you have to be dealing with that level of compliance as well. But like a mentor once told me, look, compliance really is down to perception, and it's down to learning as well. So whether it's dealing with very intelligent counsel on the plaintiff side of a class action or dealing with the regulator, a lot of times it's also about ensuring that whoever you're speaking to understands the business that you're doing, understands what it is you're trying to achieve, and understands that to a large extent there is humanity in the work. So people say a lot about big tech, or a lot generally about tech companies, but within the company there's people out there who are ensuring that a lot of the work being done is ethical. And I would always beat my chest anywhere I go to say that, look, Welltech is one of the most ethical companies out there. I'm sure the rest, I'm sure general counsels from other companies would do the same. But making sure that we do not cross that ethical byline, and making sure that user experience is not just a word being bandied around for the sake of it, is something that's very, very critical to me. And I guess on the top of the umbrella, it's what keeps me up at night.
Excellent.
Scott, let me just add some information here before go to Miguel. The figures I have here, I think they are interesting, and also reinforcing what Kaelo was saying. 52% of people last year have seen fake news or articles. Almost 14% have seen fraudulent product reviews online, and 52% have experienced deepfake attacks or scams for personal information and or money. But this is very important what you were saying about how the companies must make trust as a top priority. And this passed by adopting responsible AI principles, ensuring transparency, accountability, clear accountability, explicability, and governance from design to deployment and uses. This is very important. This is something that we as in-house lawyers are very focused on. Conduct AI risk assessment is very important to monitorize the implementation of these measures, and also to ensure the human-centric approach and the human supervision approach. Invest in security measures, and collaborate globally to ensure that all the departments in the company incorporate these principles of responsible AI. I just wanted to add this to reinforce what you were saying, that is exactly what an outside counsel focuses on.
Absolutely.
And an in-house
definitely.
counsel.
I mean, look, trust is literally the most important thing out there, because whether it's regardless of what sector your business intersects in, it's very critical that the user trusts you, right? And the first thing that they do when they give you their data, literally, is that they deposit their trust in you. And sometimes it's very critical that there's a collective understanding that very few people, and this, I use the word very carefully so as not to exclude the existence of bad actors, obviously, but very few people would willingly breach that trust. And a lot of companies do all they can and spend all the money that and have incredible budgets just to ensure that user trust is safeguarded.
Yes. I think those are interesting perspectives, particularly in one of the panelists yesterday on the plaintiff side talked about valuing cases along three axes. One of them was procedural strength, one was substantive strength, and the third that jumped out at me was the outrage factor. And I think that avoiding and mitigating and cutting down the outrage factor is very important. Miguel, you're come at this from a slightly different angle. We have a consulting firm, we have a tech firm, and now we have an investment bank, which is more of a brick and mortar, I guess, company. What keeps you and your business up at night?
Yes, they give you data. To me, they give me their money. Not to me properly. But I think that we have a problem of trust in the legal systems, mainly about the anti-money laundering systems, because in ancient times, commercial law was about trust, and our clients always trusted in us, and we trusted in them. Mm-hmm. And nowadays, we have to distrust, and we have to have due diligence for our clients, and our clients are always distrusting us too. But trying to present myself. So, good afternoon. My name is Miguel. I'm the head of legal of Banco de Investimento Global, BIG. It's a medium-sized bank based here in Lisbon, Portugal, with a strong digital component since its beginnings. We are currently a group of companies that also includes a bank in Mozambique, a brokerage firm with activities throughout Europe, mainly from Spain to Poland, but mainly in Spain and in Poland. And we also have a branch in Spain that is growing rapidly. In addition, we have a venture capital company that looks for startups and new companies to support and grow also around Europe. In this role, I have to coordinate an in-house legal team, and I rely on the support of various law firms that give us specific counsel to confirm that we are compliant with the laws and regulations of various jurisdictions in which we operate. What keeps me up at night is to guarantee that we comply with everything, and I really think that is impossible in an Europe that loves to regulate. But my okay to an idea in a bank can put us in jeopardy every day. I need to support our board of directors. I need to oversee our legal risks. I need to ensure compliance and corporate governance. And I also manage litigation, which in our case, fortunately, is exceptional. And I participate in policy development and training of our teams. About compliance, I also think I wrote an article about the compliance laws of Bank of Portugal, and I think that my image is like compliance are like the sales of a boat in a bank, or the map, and with compliance, only with compliance, we know when we have favorable winds. Without compliance, we don't know where we are going to. So I think that the second part of the question will come now, so I will not go further.
Yeah, and I guess thank you for that. And I think the second part of the question is, you've identified what keeps you up at night. How, as an in-house counsel, do you go about being a good partner to your business clients and enable them to at least stay away from these risks, or even better, turn the risks into an opportunity that will maybe separate you from your competitors?
Yeah, let me take a step back to highlight that the role of legal departments and in-house lawyers evolved from the traditional legal advisor, or just compliance guardian, to a strategic business partner that helps the company and the senior leadership to define how to embrace technology, innovation, and how to differentiate in the market. So I used to say that in-house lawyers cannot be averse to risk. Well, all the lawyers, but especially in-house lawyers.
You can't just be the Department of No. Right?
Yes. We need to identify the risks, but also in parallel identify the solutions and the way the company can do business within the legal boundaries and according with the legal requirements. This is essential. In one word, I would say that the in-house lawyers must act as innovation enablers.
Of course.
And by look to the emergent technologies, by look to them in a positive manner, and this way find ways to leverage this technology in a way to precisely helps the company to have a different mark in the market. and to help them to have an advantage from a competition perspective. How do we do this? Again, with the strong policies, internal policies that we need to ensure that are followed by all company. Work a lot with the teams that are in the project, so the product and tech teams. Train them in what concerns to the legal requirements, and also ensure that we as lawyers understand the technology and the risks, because we can only mitigate the risks if we understand exactly the risks that those technologies represent. And focus on ensure that the company has in place all what is needed to ensure this transparency and a responsible and ethical use of the emerging technologies.
Thank you. Thank you. Kaelo, from your perspective, how do you help your internal clients manage risk? And I think you've maybe touched on that some, but also to use it as an opportunity for distancing yourself from your competitors.
One of the things that I found across the years is that when you're working with engineering teams and product teams, you're working with some of the most brilliant minds around. I mean, lawyers were brilliant too. Don't feel left out. But these are people who drive innovation to the limit. And working at Welltech, for example, you find people who have a goal and go a bar higher, right? It's very easy, like borrowing your words, to be seen as the major ambassador of the Department of No, especially when you've seen the guardrails from a helicopter view and you've seen where all the pitfalls can exist. But, look, the thing about working with, in a cross-collaborative way is that you're working from the very beginning at every iteration. So if it's an update, for example, that relies heavily on AI, you already know where the pitfalls are, you know what the EU AI Act is thinking down the road, you know already what the FTC has said recently, and you already know what litigation looks like as far as AI goes. And so you are thinking that far ahead, right? And so it's for me, compliance is an advantage. It's an advantage because, again, it's a perception game. If you are seen as being a top-tier compliant company, you move the spotlight away from you. Secondly, if you are compliant, then you have enough time to focus on other things while people are busy just racking up a larger litigation budget because they know it's coming. And you're just really prepared for it because you've done your internal compliance audits, your product level audits. You know that you've done audits across everything, whether it's transparency, whether it's user experience, whether it's down to content safety, and you know that you're good. And essentially, at that point in time, you have the edge. And you have the edge because you're able to then advance, take 3 steps ahead where certain companies are still lagging. And I'll give you an example. Some companies in, say, the FANG or in big tech, for example, have hired certain roles in anticipation of certain issues. And whether it's in the health tech space as well, you see certain companies, Welltech included, making space for certain roles as well in anticipation of certain regulations, right? Some companies are take a wait and see approach. I guess that could be advantageous depending on how much of a hit you're ready to take. But then in some situations, it pays a lot of times to get your internal clients ready, just speaking to them at the iteration stage, winning their trust, because external trust with the user is one thing, but being the go-to person or the go-to team internally is very critical, especially when you're working in-house. They need to see that you're working with them. They need to see that you believe in what they're trying to achieve and that you're also trying to just drive it 2 steps ahead. So they know that, okay, this update is really good, but we can make it better by adhering to everything that Kaelo is saying or anything that Kaelo's team is saying. Because internally, within the legal team as well, there needs to be that sort of like that smooth dance where we also understand what we're trying to, the message we're trying to put out there, so that we're not working at cross purposes, right? So it's very interesting how the gears sort of like tick along the way. One of the things I did very early in my career was just really just mapping out who my most critical stakeholders are, right? Everybody's important, but there's the more critical stakeholders. So you're looking at your engineering teams, your product teams, your marketing teams. If they're separate from the advertising teams, you're looking at them too. If you're looking at, if there's a public policy team, you're working with them. If there's a content moderation team, you're dealing with them. If there's a team of medical experts, you know, you're working with them. So you're working across board even with the data teams as well. And you find that even within those teams, you're able to sort of like draw out ways to be more compliant that you as a lawyer didn't think about. And at the end of a long span of working with teams like this, you're even more technical. So you find that people who work in-house are very technical and very close to the sort of business that they're doing. You know, sort of like Joana might be very close to the bloodstream of the business of Accenture and Miguel as well. So it's just, you become very technical, and that also helps with understanding the regulatory playground that you're working within. So it's
Excellent.
Yes, as I said, we need, and we are business partners. We need to understand, and this happens a lot to me. I'm in the room with the business team, sometimes just here when they shape the solution and participate in the shape of the solution since the beginning. Understanding the financials, other thing that is very important. Follow the money. Understand it. Think about the best contractual models to apply in that case, the contractual structure, understand what is the client need is also very important to identify risks and mitigations and to shape the solution in a way that is good for both sides. So all of these aspects helps us to help the business teams to get what they want.
Very good. Miguel, what's your perspective?
To gain time for my next question,
You're gonna
I will
forgo.
try to shorten my answer now. I think that we need to have a proactive risk assessment, and Kaelo was talking about audits, and that's really, really important. Nowadays, the main bad guys are the auditors, internal or the external, then the compliance, and that makes us a part of the business. So what Joana wants for lawyers to be a part of the business is more easy if the compliance and the auditors do their work properly. And I think that if we conduct regular audits to identify potential risks in different jurisdictions, and then we search for specific partners in each one to solve these problems, it's the greatest solution. Then we need to provide regular training, in my case for bank employees, on legal compliance. And today we talked a bit about data protection, but in my sector, this was banking secrecy that was a problem for centuries. And I think that we have this problem, and we need to have educated teams, and they are better equipped to recognize and avoid actions. To end, we need to form strategic partnerships with other institutions to share knowledge and resources. And after some of these audits, internal, external, or even by our supervisors, in Portugal, by Bank of Portugal, by the Portuguese Securities Commission, if we detect and list findings and opportunities of improvement, we must immediately act and change our behavior. It's easy to remember lots of cases around the world where some strong cases transformed institutions.
I think this is all very interesting because, again, as a person who typically, I do some of the consulting side, but as a person who's generally involved in litigation, what I'm hearing is this is a lot of strategies for avoiding litigation, but when litigation does arise, it takes away some of that outrage factor. I hope the plaintiffs' bar is listening because my experience is these three are not outliers when it comes to internal people trying to get it right. I don't know. I know everybody recognizes they don't always get it right, but it's certainly that. I think this cuts across many clients. We're down to very little time. Miguel, I know you've done a lot of thinking about the issue of the Representative Action Directive and what that might mean in Portugal for your client and others. And you want to give us some thoughts, recognizing we're down to about 5 minutes. I guess we get as we would say in the States, you get the Cliff Notes version.
Yes, I'll try to be fast. I think that we need to understand the directive and its transposition in Portugal. In Portugal and the other jurisdictions we operate. First, I have to say I have no current experience in class action litigation, both in Portugal or in Europe. However, I'm not a believer in class actions in continental Europe or in civil law as strong as other speakers we heard during the last days. I hope Joana and Kaelo might be more optimistic. I tried to follow the transposition in a task force of this directive into Portuguese law, and I think that, as in other instances, we tried to be in Portugal the good student of the European Union and receive the new regime to its fullest extent. And as Pedro said in the last panel, we also have done some experimentalism that can be dangerous. However, before approving the new law, we already knew, or should have known, some of the problems that were happening in Austria or in Italy with their respective transpositions. Today, in the second panel in the morning, we heard about difficulties by Christian in Spain, by Dimitri in France, and they talked about incompatibilities of the main features of the class actions regime with their systems. At my school, I'm a comparative law teacher, and I really love comparative law. And I published a book on comparative law this year, and I love some of its creations. But I think that sometimes civil lawyers, like me and some members of the audience here, are attracted to American or British creations and solutions that do not work properly with our civil or criminal procedure codes. It is like trying to play a part of a song of Elvis Presley or Frank Sinatra inside of a Beethoven symphony. It doesn't work and it doesn't sound well. It sounds terrible. And I love to hear Elvis or Sinatra or Beethoven, but separately. We have a need to have different mechanisms to protect our consumers. However, we have this directive in Portugal, and I think that with that in mind, we need to have three approaches. First is to monitor all jurisdictional developments at national or European level, engage with local experts in academia and in practitioners of law, and develop strategies with better compliance programs, considering the possibility of simultaneous actions in different jurisdictions at the same time. It can be a reality in the European Union. We need to give regular training to our lawyers on these matters and prepare for third-party funding, which I'm a bit scared about. However, at the same time, we have to respect our other alternative solutions more in line with civil law traditions. First, we have ombudsman services that handle consumer complaints and disputes, often free and with less formal procedures. And we talked a lot about the high costs related to class actions during these days. We also have alternative dispute resolution methods that are being reinforced with new regulations and protocols between the supervisors and the banks and the entities, for instance, in the financial sector. We also have a public enforcement. We have lots of regulatory bodies, much more regulatory bodies in Europe than in the USA, that can take action against businesses that violate consumer rights. I've written recently a paper on the role not of consumer protection agencies, but of the Portuguese Central Bank as a protector of the consumers. These bodies can, and they do, impose strong fines and enforce the law rapidly. Finally, we also have countries, not Portugal, with small claims courts designed specifically to handle low-value disputes in simple and faster processes. Companies doing businesses in Europe face now lots of new hurdles after this directive and law. Representative actions are brought by qualified entities, and I think the main strategy will be to contest their standing. So it's my main and first idea. Secondly, representative actions can be domestic or cross-border. This regime is still very young and will be fought in courts in lots of countries. And as Christian said in the morning, we'll have lots of bumps around the road. We have in the regime measures to avoid abusive litigation. And I don't know if companies will abuse the abusive litigation methods to contest manifested and funded cases. As some speakers explained, Portugal adopted a pure opt-out mechanism. Only Netherlands and the United Kingdom have these regimes in Europe. It can be dangerous for consumers to have this regime, for capture of the regulator or capture of the association, and this solution is being very criticized in Portugal. Our competition court in Portugal is also discussing conflicts of interests problems about third-party funding. The directive also aims to protect consumer interests in many areas of law, but not all. And I don't know if we can find loopholes with this design. Portugal was a year late after the directive should be published. And to compensate, I think that perhaps we went too far. In conclusion, countries like Ireland or Netherlands were not too enthusiastic to transpose and apply these class action regimes to their fullest extent because they want to attract companies, US companies or UK companies after Brexit. They want to be our Delaware. But I think that the reality is different in Portugal because we have a constitutional provision from 1976 that prepared the way to receive in our system ideas like class actions, our popular actions. However, I still want to see how our case law will apply the new regimes, how long these lawsuits will take, and how efficient will they be to protect consumers. We need to be prepared, but right now we have lots of uncertainty and unpredictability, and that is never good in legal systems or in life.
On that note, we have many other things we were prepared to talk about. We are at or over time. Thank you for your attention. I will speak for myself. I intend to be upstairs. If you all want to engage any of the panelists with any of these issues, I'm sure they'd be happy to do that. So please join me in thanking them for their preparation and participation.
Thank you.